And good morning or afternoon, everyone. Thanks for coming out today. My name is Marvin Schwartz. I'm the COO here at hrsimple.com. Also would like to welcome Robin Shea. She's from the law firm of Constangy, Brooks, Smith, and Profit. She'll be starting our webinar shortly with Not Suitable for Work as the topic for today. The law firm itself, they write our model policies and forms for Georgia employers and the soon-to-be published New Jersey Human Resources Manual. And we're happy to have that back again. Robin is a partner, like I said, in the Winston-Salem, North Carolina office for Constangy, Brooks, Smith, and Profit with over 30 years experience. She provides advice to employers, conducts training for human resources professionals, management, and employees on a wide variety of topics. Also the editor-in-chief, author of the award-winning law blog, Employment and Labor Law Insider. And we're very happy to have her here for this presentation today. Do know this presentation lasts for about 60 minutes. If you have any questions, you can write them in the question box that's below. We'll try to get to some of them during the presentation. The rest of them we will also try to get to at the end of the presentation. Also, if you're here for the SHRM credit as well as HRCI credit, we will have both of those codes up at the end of this presentation so that you can get that credit for being at this webinar, as well as contact information for Robin and myself. So without any further ado, I give you Robin Shea. There you go. I think we actually just figured it out. Robin, are you there?
Yeah, can you hear me?
There we go. Sorry for the glitch, everybody.
Okay, so, okay.
Gets much better than here, I promise.
All right. Well, hi, everybody, and thank you for your patience today. My name's Robin Shea. I'm an attorney in Winston-Salem, North Carolina, and my law firm represents employers in all aspects of labor and employment law. Our topic today is not suitable for work, and what we're really going to be talking about is the legal risks associated with behavior that technically is not illegal. So I think it speaks well of all of you that you wanted to do this webinar and kind of go beyond what your legal requirements are and actually focus more on prevention. This is sort of the legal equivalent of eating your vegetables and exercising every day as opposed to being treated for an illness. So what we're going to talk about today is cursing in the workplace. You kiss your mother with that mouth. Maybe you should save it for home. And these are topics that are perfectly fine to discuss in some contexts, but maybe not the best topics to discuss or behavior to engage in the workplace. Weapons on the job, and then Gadget glut, which is really bring your own device policies and some of the risks associated with those policies and what employers can do to minimize their risks. So let's get to the cussing first. Cussing is generally technically not considered to be any kind of unlawful activity or harassment, but the context can make a big difference. And one thing that comes up a lot for me when I'm doing employment law training or harassment training for clients is, what about those cuss words that have double meanings? And let me give you some examples. Mary wrote me up for being all of 5 minutes late this morning. That, you know what? I'm not going to say these words, but it's a synonym for a female body part. Oh, F me. Yesterday was April 15th and I forgot to mail my tax return. Or what the F? I just met the new supervisor. He's a real D, and you won't ask for a raise because you're just a big P. All those words have sexual connotations. Now, are you engaged in sexual harassment when you use those words? I would argue not. And actually, if we had to go to court over this, I would argue to the death that you did not violate a sexual harassment policy by using those words, because in these contexts, they're not being used that way, right? They're just being used as expletives. So I would say, no, this is not harassment. For it to be harassment, the unlawful harassment has to be based on somebody's particular protected characteristic. With some of those comments, we may have a little bit of that or we may not. You know, when you're calling somebody the P word for being a wimp, you might address that to a male or a female. It may have absolutely nothing to do with their protected characteristic. In other contexts, it might, if you're talking about a woman calling her the C word or the B word, or you're talking about a man and calling him the D word, then that would be somewhat tied to that. The harassment also has to be severe or pervasive, and usually just using a word like that in the context we're talking about, using it as a cuss word, as an expletive, would not be considered by the courts to be severe or pervasive enough to give rise to a sexual harassment claim. And again, even though all these words do have sexual meanings, for sure, they have obscene meanings, in these contexts, they're not really being used that way. They're just being used as curse words. And so I would say, yeah, these are not very nice ways to talk at work. You probably don't want your work environment to have that kind of language going on, at least not very often. But it's probably not illegal for people to talk that way in that context. So, okay, it's not illegal. Is it a good idea? No. Language like this, especially if it's used a lot and not just very sparingly, is obviously going to be offensive to a lot of employees. And they may view it as harassment, even if you didn't mean it that way or your employees didn't mean it that way. So they may perceive that language as being harassing, especially if you are referring to, say, a female supervisor as the B word or the C word, or a male supervisor as the D word. There's probably at least a 50-50 chance that somebody's going to look at that as some type of harassing or discriminatory comment about that individual. So I would say if you have a workplace with a lot of that really bad language going on, you are probably going to be at higher risk of at least having complaints come to HR, complaints of harassment based on employees who perceive that behavior as being inappropriate, or actually being named in a harassment lawsuit, or being, you know, your company being accused of having a hostile work environment based on that type of language. So it's not good. It's probably not harassment, but definitely not a good thing, and especially if you don't want to be involved in a lot of harassment litigation. And I'm sure no one here does. So I've got 7 rules about dirty words at work, and number 1 is cuss sparingly. I think, you know, cussing is normal in most workplaces. Before I went to law school, I worked in a newsroom for a newspaper, and I can tell you there was plenty of bad language there. The lawyers are actually a little more sedate, I think, than the news people were. Depending on your work environment, you may have a lot of that. People need to keep it under control if they can, to the extent that they can. Number 2, when you must cuss, try to use words that do not have sexual meanings. Hell and damn are good words to use if you got to cuss. They don't have any sexual connotation that I'm aware of. If you use that word, you may still offend some of your coworkers because you're cussing too much, but at least you will not be accused of sexual harassment for using those words for the most part. Number 3 is one I actually had a lawsuit that involved this as part of the lawsuit. If you take the Lord's name in vain, do be mindful of your coworkers who may be religious and may be offended by that. this case I was thinking of years ago. I had a former employee who sued for religious discrimination, and among other things, he accused his plant manager of saying GD all the time and saying it in his presence. And he objected to that. He thought it was inappropriate, and he also felt like the plant manager was saying it around him, knowing that he was religious and knowing he was offended by that behavior. So if you do use the G word as an expletive, be sure you are sensitive to your religious coworkers. We did win that lawsuit eventually, but again, who wants to go through all that, and not to mention the legal fees. Number 4, never cuss at a particular individual. It's one thing to, drop your stapler and say, damn it. It's another thing to say, damn you, to your coworker. That is much more likely to cause problems in the workplace, get a report to human resources. So don't do that. And also, I would say don't ever cuss about an individual behind their back. So-and-so's an SOB, so-and-so's a B. I'm sorry, I've got a fire engine coming down my street. I apologize for that noise. But the more the cussing is directed at any particular individual, I think the higher risk it is that you will be accused of harassment or discrimination against an individual. Number 5, when you cuss, even if you use the nice cuss words, I call hell and damn the nice cuss words because they don't have any sexual meanings, and they're also relatively tame compared with some of the words that we have out there. Don't direct your cussing toward people in any particular protected group. Again, cussing normally is not harassment, but if the only people you ever cuss about are people in a particular racial group or ethnic group or, some other protected category, then you could be at risk of some type of harassment claim. So don't do that. Be an equal opportunity cusser when you have to cuss. And never cuss in front of a customer or a client. And this is not so much a legal issue, it's just a business issue. If you have a client or customer who cusses a lot, then maybe there's an exception for that. But normally that's just not business-like professional behavior that you would want to have. And then finally, number 7, apply these same rules to cursing that may have double meanings based on race, nationality, disability, age, sexual orientation, or gender identity. Especially with those last 2 categories, I can think of a few words that might be used just as a general expletive, but that also seem to be targeted at people of different sexual orientations or gender identities. If you're going to use those, don't use those words in the workplace, because again, like using the words that we gave examples of, the P word, the D word, the C word, the B word, those are likely to create some type of harassment complaint, either internally in the company or an actual lawsuit or EEOC charge. So those are my rules about cursing at work. Does anybody have any questions about any of that before I move on? Okay, well, we will move on to our next topic, which is saving it for home. These are also things, they don't necessarily involve any legal issues, but they can create complications in the modern workplace. And so we have to be careful about how we bring these up, or whether we even bring them up at work at all.
Hey, Robin, there actually is one
Yes.
question here that says, what are nice curse words?
Nice curse words. In my opinion, the nicest ones, and realize these are all curse words and none of them are really nice, but the nicer ones would be hell and damn. And then maybe the intermediate category I would say would be BS, or calling somebody an a-hole. Not that those are nice words, but they're not. They're kind of gender neutral. They don't have pornographic implications, so they're a little better than some of the ones I gave examples of. The ones I gave examples of actually have explicit sexual meanings, even if they're not used in that context. Oh, okay. Political debate.
I got one more question for you. It's okay.
Sure.
It says, what if your boss is being spoken about on Facebook in a negative and slandering manner?
Oh my gosh, that's a great question. I would have a lot of questions about that, but generally, employees are allowed, assuming these are non-management employees talking about the boss, they are allowed a little bit of legal leeway to vent about working conditions, and that could include the quality of supervision they're getting. If it's actually slanderous, it is a false statement that would damage the boss's reputation, and it was made either knowing that it was false, or with what the courts call reckless disregard for whether it's true or false, then that may be a different story. But generally, employees are allowed, and this comes mainly from the National Labor Relations Act, even if they're non-union, they're allowed to talk about their terms and conditions of employment, and that would include even on social media. If you have more specifics, I'd be happy to talk more about that if I think we probably have time, but that would be my general answer. Okay to move on? Okay, political debates. We have a First Amendment right to speech. It doesn't apply in private sector workplaces. There's no First Amendment right to not be disciplined or even fired by your employer because of what you may discuss in the workplace. I think right now, especially with the political climate we have now, with such polarization, employees need to be really careful about getting into politics with their coworkers. Number one, coworkers may not agree with you, and maybe 20 years ago you could have a civil disagreement about that and it was no big deal. I think nowadays it's going to be much harder for most employees to have a civil disagreement about politics. And so if you bring that up and you're very partisan, there's a good chance that's going to blow up from a work standpoint. Hot button topics, especially the hottest ones I think right now that are most likely to result in problems for employees who may talk about them at work, are affirmative actions, one that's been around for a long time. I've always felt like that was a dangerous subject to get into in the workplace because, especially if you're opposed to affirmative action, your coworkers who may be members of racial minorities, they may be women, whatever, they may view that as your view that they're inferior and the only reason they got to where they are is because, somebody made special allowances for them. That is not a good topic to discuss in the workplace, in my opinion. A newer one, LGBT rights. I think that's another one that has the potential to be very, very inflammatory and, could really cause hostilities in the workplace. Everybody has a right to their opinion, but maybe work isn't the best place to talk about it. And then immigration is another one that is recent. That's one that I used to have women working outside the home. That one seems a little dated now, but we used to have that issue come up a lot, and even 10 years ago, where a traditional father usually would say something to the effect to his female coworkers that he thought women, it was a noble calling for a woman to stay home and raise the kids and not work outside the home. And that used to cause a lot of problems. I haven't heard much of that lately. But immigration is one where I think, people just feel very strongly about it one way or the other, and it's hard to have a conversation that is, where you can express civil disagreement. So I'd say stay away from any of those topics in the workplace. And of course, we know in a real workplace, you probably pick out the people who agree with you, and you may be able to go have private discussions with them about your opinions. We may not be able to do a whole lot about that, but I would say at the very least, be very careful about who you talk to about these topics, and be as discreet as possible in raising those topics. So that's political talk. One other thing I should mention is religious talk is another one of those areas that can be dangerous. I'm going to just be very generic here. Let's say you have a workplace with some evangelical Christians and you have some Roman Catholics working together in the same office. You need to be careful about your discussions about religion. And I would say, number one, it's fine to usually discuss it with people who are like-minded. If the two evangelicals are talking about going to church on Sunday and, we'll see you there, that type of thing should not be a problem at all. If you're having a constructive, consensual discussion with somebody who disagrees with you, maybe the evangelical and the Catholic are talking about what they agree on and what they disagree on, and it's very civil and they're both being very respectful of each other, that should be fine. Where you really get into trouble with religion is, number one, if you try to convert your coworkers to your religious beliefs, and that can include preaching, that can involve aggressive invitations to go to my place of worship, and you've already told me no, and I just keep after you about it. Or from the other side, from the non-believer side, disparaging people who believe. And that is also a form of potential religious harassment or discrimination. So beware of religion as well as politics in the workplace. Then, of course, we've got surfing the internet, and got a couple of concerns there. Number one, you need to be doing your job while you're at work, so we've got that concern. And then second, you don't want to be surfing to websites that have inappropriate content. And your employer may already be filtering those out, and you may not be able to go to those. But if you do have more freedom to surf, be sure the places you're surfing are appropriate for the workplace. And if you want to do inappropriate surfing, save it for when you get home at night. Same rules would apply to reading material, and I'm talking about, of course, anything with sexual themes, but also racist material or, I hope nobody on this call would have this issue, but, neo-Nazi material, that type of thing. You don't want to have that in the workplace or anywhere, really. And then finally, we have inappropriate relationships. So this isn't reading material, but, even if there's a consensual relationship between two individuals, there could be harassment allegations as a result. And that could include a dating relationship. The one that I think is the worst by far is an extramarital affair between two people who work together. As you can imagine, an extramarital affair is likely to blow up somehow or other in a way that's going to be bad for somebody. It could be that one of the partners to the relationship decides they want to stay with their wife. Could be a spouse found out about the relationship and went to HR and raised Cain with HR. All kinds of things can happen. So in my experience, and I've been defending employers in harassment litigation for probably not my whole 30 years, but maybe 25 years, I have found that the number one high risk factor for being accused, for a man to be accused of sexual harassment, is to be having an affair with somebody he works with. And you think about it, what happens when an affair breaks up? One party is left high and dry. If it's the woman, she may accuse the man of sexual harassment. If the man is the party who's been jilted, what we normally see is more of a stalking situation, and he may not be able to get over it, and he's stalking and scaring her and maybe threatening her, and sometimes threatening with severe physical violence. So extramarital affairs are really a terrible idea at work. They're not illegal. It's not sexual harassment to have an affair with somebody you work with. But it is just an extremely high-risk behavior, and I think it is the number one high-risk behavior in the workplace that results in sexual harassment claims. Even if it's not that bad, we have to worry about things like favoritism. If you're having a relationship, especially as a supervisor with somebody who you work with, other employees are going to perceive you as playing favorites and giving all the good assignments to that person. And most companies do have a policy that if two employees are in a relationship with each other, they cannot report to each other. One of them has to move or leave the company. And my only caution there is, back in the really old days, it was always the woman who had to leave the company, and the husband got to stay and continue working. In this day and age, of course, most employers just let the couple decide who's going to stay and who's going to go, and let that be their decision rather than the company's. And that way, it's their decision and it's not discriminatory. Are there any questions about that before we move on to our next topic? Okay, I'm going to move on. Weapons on the job. This is kind of an interesting issue. Some of you may be surprised to know that many states require employers to let employees keep firearms in their locked vehicles, even if the cars are parked on the premises. And this is one of those situations where the red states may be more regulated than the blue states. The red states are more likely to have those laws in place, generally speaking, than blue states. So be careful if you're in a red state and you find out that an employee had a gun locked in their vehicle. Be sure you check applicable law in your state before you take action against that employee, even if you do have a no gun policy or a no firearms policy. They may have a right to keep that gun out in their locked vehicle despite what your policy says. Now, most states do, most if not all states do say that employers have the right to restrict weapons inside the workplace or on the company property as long as it's not inside a locked vehicle. So, once the employee brings that weapon out of the vehicle, assuming they're not just trying to store it and lock their vehicle and it's just out for a minute while they do that, once they actually bring it out of their vehicle, then you can prohibit that generally. But there are still very specific requirements in certain states requiring employers to have signage up. And in some states, the sign has to be a certain size and the letters have to be a certain size font. So make sure you're complying with all those laws if you want to ban weapons on your company premises. And of course, security guards, people like that who have to carry weapons as part of their job are in a different category, and most of the laws make exceptions for them anyway. One question that comes up sometimes is, should employees be allowed to bring guns to work or other weapons to work to protect themselves and protect each other, you know, from active shooter scenarios? And of course, the latest, well, we had the shooting at the synagogue in October, and that became a very hot topic. There have been shootings since then, unfortunately. So would this be a good idea? I think it's worth talking about. I'm still in the camp that I'm afraid the risks of having lots of armed employees may outweigh the benefits that would come from that. So I'm still not in favor of it, but I think it's worth discussing that at least, and discussing whether that would be a good thing to do. Are there any questions about that? Okay, and then we move on to bring your own device policies. What do we do with all the gadgetry? A lot of employers now just have employees, you know, they buy their own devices. They may get reimbursed in part for those devices. They may not. But those devices are used both for personal reasons and workplace reasons. Nothing wrong with that. Nothing illegal about that. But here are the risks of those as opposed to for example, a smartphone that's issued by your employer that's used only for company-related reasons. Number one, if employees buy their own devices, the employer automatically has less control over that device than it would if it was just a company-issued device. So that's always scary. When you're mixing business and pleasure, that's always a scary thing, at least for us lawyers. There is a greater chance, I think, with an employee's own device that they're going to engage in some behavior on their device that they think is fine because, you know, it's personal, it's my device, I can do whatever I want. This isn't using the work email. And so they start doing inappropriate things like sexting or harassing each other using their devices. And they may feel more freedom to do that if it's their own device as opposed to a company-issued device. And even if it is their own device, they're still at risk for possibly having a harassment claim or getting in trouble for violating company policy, all kinds of things. So, you know, I think the bad thing about the BYOD trend is, to the extent that employees feel freer to do whatever they want because it's their device, that could present more risks for the employer, more legal risks, and for the individual employee who owns the device. The other problem we have with any kind of mobile device is wage and hour violations. You know, if you have a smartphone and you are getting email from work on it, and you're non-exempt under the Fair Labor Standards Act, and you respond after hours and you may not think anything of it, and so you don't put it down on your time, then the employee could be putting the employer in a position where they are going to be at risk for wage hour violations for not paying those employees for all-time work. That is not an issue with exempt employees. So if you're a manager, a supervisor, or a professional or some other FLSA exempt employee, none of this is an issue because you get paid the same no matter how many hours you work. But with non-exempt employees, employers really do need to be careful and make sure that the employees either don't use those phones or devices for business purposes after their regular hours of work, or that if they do, they put it down on their timesheet and get paid for that time. And that's hard to do. I'll talk about that a little more in a minute. And then, of course, we've got the concern about the security of employer information, especially confidential and proprietary information, or maybe personnel information, where you've got the employer's information mixed with the employee's personal information because it's the employee's own device. There are risks associated with that. And then hopefully this doesn't come up too often, but it does come up from time to time. In the event of litigation, normally attorneys would advise their clients to preserve any emails, any other electronic evidence, as well as physical evidence related to that particular legal dispute. So if you get an EEOC charge from an employee accusing the company of discrimination, your attorneys will tell you that you have to, turn off any kind of auto-destruct mechanism in your email, make sure that all that employee's emails are preserved, as well as the emails of maybe that employee's supervisor or other witnesses to the alleged discrimination. All of that would have to be preserved. The personnel file would have to be preserved. Any supervisory notes of investigations or anything would have to be preserved. And that's not too big a deal on company-owned devices, but it is a little more of a challenge when the employee owns the device. And especially think about a third-party witness. I'm not even the one accusing the company of discrimination, but maybe my name came up as somebody who witnessed something. And I may have some emails or texts that are relevant on my mobile device. You would actually have to work with me to preserve that evidence on my device until the litigation has reached its conclusion. And you have to save it until the bitter end of the dispute. Either, there's a final court decision that can't be appealed anymore, or the parties have settled the case, and so it's over because of that. Those are the only times you can release employees from those litigation holds. So what do you do if the employee owns the device and they may have relevant evidence on their device? So these are all some of the complicating issues related to bring your own device policies. There are ways to deal with these. If an employee quits or is terminated, and of course they've got, maybe your Microsoft Exchange email account on their mobile device, they may have other employer information on their devices. By all means, make use of remote wiping software. Microsoft has that. It takes about 5 minutes, and the administrator with the company can erase what was on that employee's device. And they actually have a couple of options. One is they can do a partial wipe, which it's kind of nice because it just wipes out the company business information and leaves the employee's personal stuff on the device. The only trouble is there may be company information tucked away in spots that would not catch. And then the other nuclear option is for the wiping software to just restore the device back to factory settings. And that would cause the employee to lose everything on their device, including photos, everything. And it's just set back to its original settings. And that's another way to do it. But you do really need to do one of those two things when an employee quits or is terminated to make sure you've protected your information as much as possible. When you do harassment training, it should include discussion of appropriate and inappropriate use of mobile devices. I have seen a lot of cases in the last few years where people think they can sext each other on mobile devices. Coworkers sext each other, and they think, it's my device. Nobody's ever going to know the difference. That's not true. It is going to come out. And if somebody, you send me a sexy text and I don't appreciate it and I report you for harassment, you can be sure that those texts or sexts are going to be found by the company, and they may take appropriate action based on the harassment policy. So that needs to be covered in harassment training every time you do harassment training. And I hope everybody is doing harassment training at least once a year. And management, by all means, it needs to be done for management, but I think it's a good idea to do it also for employees. And in this Me Too era, it's worth considering requiring your board of directors to go through the training too, in case there's an accusation against your CEO or somebody very high up in the organization that has to be delegated out. Make sure everybody in the company who could be a victim of harassment or who handles harassment complaints in any way has been through training and that it's relatively up to date. Back to bring your own device policies. Another good preventive step is for employers to have clear policies for non-exempt employees about their responsibilities after hours. What's the rule? Everybody ought to know what the rule is if they're a non-exempt employee. Am I supposed to just turn off my email when I leave at 5 o'clock in the evening and not check it again until I'm back at my desk at 8 in the morning? Is it okay for me to check my email as long as I make sure I put down that time in our timekeeping records? Whatever the rule is, employees need to know what it is so that they can follow it. Don't just assume that because their work schedule is 8 to 5 that they aren't still checking emails or taking phone calls while they're commuting home from work. That can create some really serious wage and hour issues for overtime or just wages, regular pay for hours worked. And the other thing I would say is you probably have a lot of non-exempt employees who are dedicated and conscientious and professional and want to do a good job for your company. And those employees are going to be very likely, unfortunately, to do what needs to be done, not quibble over posting. If they have to spend 15 minutes responding to an email from the boss at 8:30 p.m., they're not going to quibble about it. They're not going to bother putting it down in their time. They just think that's part of my job, because they're good employees and they care about doing a good job. The sad thing is, even though those are great employees, they're probably the highest risk from a wage and hour standpoint because they are the least likely to post their time. Even if you tell them to do it, they're not going to want to do it. They're going to, not silly, this is part of my job. That's the way I like to, I'm not going to put down 15-minute email exchange with the boss at 8:30 at night. If he needed my help, no big deal. You need to make sure that when you're going over your policies that you explain, no, we really, really do want you to post that time, or we really, really do want you to quit 100% at 5 o'clock when you leave for the day. And we do not want you checking your email. That's a hard mentality. For those dedicated employees, it's going to be hard for them to overcome their dedication and their conscientiousness to follow that policy, but they really need to from a wage and hour standpoint. Same applies to using mobile devices while driving, the Portal to Portal Act says that normally the commute from home to the office is not compensable time, and the same rule would apply to the normal commute from the office back to home at the end of the day. That's assuming no work is performed on that commute. But if you have a non-exempt employee who is taking business calls or making business calls while driving to and from work, then that commuting time is going to be compensable time for them. And that can be very significant depending on how far away they live from the office. Normally you can have a 1 hour commute be non-compensable if no work is performed during that commute. But if work is being performed, you may owe them an extra 2 hours a day. And that's going to add up quickly. And if it's a category of employees, so you have more than one doing it, those numbers add up really fast. And that's why plaintiffs' lawyers love FLSA collective actions, where they can sue on behalf of lots of employees. So make sure employees understand, the non-exempt employees, make sure they understand, we don't want you using the phone while you're driving to and from work, for safety reasons and for wage and hour reasons. Just consider that thing a personal device till you get here. And then once you get here, you can use it for work.
Hey, Robin?
Yes.
I have a question here about personal devices actually being used at work. And it asks, what about inappropriate content that's being viewed on the personal devices? How do you deal with that?
That's a really good question. And it's kind of hard to deal with that if it's on a personal device. Assuming it's not interfering with work performance, which it might be, I would include that in the harassment training, that type of material should not be viewed at work at all, period, because somebody might come up behind you and they might see it. It's like reading a Playboy magazine in your office. We used to get a lot of questions about that in the old days. Even though that may just be something you're reading for your own personal use, there's always a risk that somebody would come along and catch you doing it, and that's why we have policies saying no inappropriate reading material in the workplace. So I would follow that same rule with employees' personal devices. Don't surf inappropriately, don't read inappropriate material while you are at work, even if it's on your personal device.
Okay. I also have a couple more questions here that have come in about workplace relationships. The first one being, can you prohibit workplace relationships?
Oh, yeah, sure. You can. A lot of employers don't want to do it. I have mixed feelings about it, because if you're talking about single coworkers, not married coworkers, but single coworkers, we spend so much time at work every day. Sometimes that's where people meet, and I have not seen dating relationships blow up the way affairs blow up. I think it's relatively unusual for a couple of coworkers who start dating each other to end up accusing each other of sexual harassment. It could happen. It could theoretically happen, but I don't see it. But yeah, to answer the actual question asked, you could prohibit any personal relationships, romantic relationships, I guess, between coworkers if you wanted to. That would be a legal policy.
Okay. Along those same lines, there's a question that says, can you fire someone for workplace relationships if you don't have a policy prohibiting it?
That's a good question. I probably would try not to terminate somebody for that unless there was some really unusual wrinkle to it that was so ridiculous that anybody with any common sense would have known it was a bad idea. But normally, no, I would, if we didn't have a policy on it, I would probably just require them to either end the relationship or have one party to the relationship move and let them choose who it is, and have that person move away from that functional area or work area.
Okay. I also have, and this goes totally different direction. Somebody asks, how do you define what a weapon is? And they say, for example, pepper spray, knife, taser.
Most of the state laws I'm aware of are dealing with firearms for the most part, but I think you could, as a matter of policy, you could define weapon the way you wanted to. You'd need to make sure you were complying with applicable law that protected the use of weapons. I have to say, it doesn't give me a lot of heartburn to think of maybe, somebody having a pepper spray container in her purse, for when she's out walking in the dark parking lot at night. That doesn't bother me too much, but I don't think there would be any problem with prohibiting that in the workplace if you wanted to, and defining weapons, in whatever way you want. I think with knives, you got to be careful because you may have legitimate knives and illegitimate knives, and so you may need to define those more specifically. But you should be able to do that, in whatever way you think is appropriate.
Okay. And once again, changing the subject entirely, I have one more question here. It says, are there any risks involved with allowing religious groups to use the workplace for events or meetings?
Oh my gosh, that's a good question. I'm assuming you are not a government employer. If you're a private sector employer, I think the worst thing you have to worry about there is maybe opening the floodgates to requests from employees of other religious groups. And if you're okay with that, if you're comfortable with that, or maybe your workforce is pretty much all of the same faith, so that's not a big problem for you, then no, I don't think there would be a problem with allowing a religious group to get together at work and have meetings. The one thing you do have to be careful of, especially if any of the members of that group are maybe in management roles, is, are they being fair and inclusive to employees who report to them who are not of that group? Because you can always have the possibility of a discrimination claim based on that. But apart from that, I don't really see a problem with that in a private sector workplace. Public sector is different because we have constitutional provisions limiting the ability of public employers to endorse any kind of religion. And so usually the litigation we see related to religious groups involves, it might involve a state university that's funded by the government, or it might involve a courthouse yard, with a nativity scene or something like that out there. It usually concerns public sector employers, not private. And if that was it for the questions, the last thing, going back to this bring your own device policy precaution that I think employers need to take is go ahead and preemptively warn employees that if we ever get a litigation hold, which we could have, if we get an EEOC charge, if we get a wage and hour complaint, if we get a lawsuit, a lot of things could trigger that. If we as a company are under a litigation hold, we may have to actually temporarily repossess your device to copy what's on it so we can preserve it in the event of litigation and not get in trouble for allowing evidence to get destroyed while the litigation is going on. I think that's good for a couple of reasons. Number one is people do, if they're using their own devices, they're going to have some expectation of privacy in those devices. They may have things on there that they would rather you not have as their employer. So they need to be warned. You know, this could always happen. If it does, we're just going to have to do it. If you got anything on that device you don't want us to see, get rid of it. And then number two, I think the good effect of that may be that it will cause employees to be a little more cautious and judicious in the way they use their mobile devices because they know that sometime if there's a lawsuit or anything that they're involved in, you know, even as a witness, as a third party, the employer is going to have the right to take that device and copy whatever is on it to preserve it. So if you're doing anything inappropriate on that device, maybe you better stop. So that's kind of a nice side effect of that. But I do think employees have a right to know that this is something we may have to do if the occasion presents itself. And I'll be happy to take more questions if there are more, but that is the end of my prepared remarks. Those are kind of the hot issues that aren't really illegal workplace conduct, but can put employers at high risk.
Any other questions?